News Radio 700 WLW.
It's about Mickeymouse, the original Mickey and Minnie that is now in the public domain, and a guy who knows from public domain and licensing issues and patents and a whole lot more, kind enough to give us some time back with Sterling on the Nation station, is the one, the only, John Rizvi on 700 WLW. How are you, sir?
Good. It's always a pleasure to be here. Thank you.
Happy New Year. Explain, if you can, real quick, when it comes to Mickey and Minnie, how we ended up in a place now where the early drawings or incantations of the mice is now up for grabs and probably sooner than later going to be doing things that Walt Disney probably would spin in his grave if he had to see in person.
Yeah, unfortunately, it's going to be sooner rather than later. And yesterday, the copyrights on the original Mickey Mouse, the Steamboat Willie version, expired, and Minnie Mouse. So they both expired yesterday, and it's after 95 years, which is the longest term of the copyright. So there's nothing Disney or anybody could do to extend that protection any further.
How does it end up being 95 years? I'm kind of treat me like a 3-year-old, and I don't understand. If I create something, I make something, I put it in the marketplace, I get a service mark, I get a copyright, I've designed something, in this case, sketches, drawings, animation, Mickey and Minnie early on in this case. You don't get to keep that forever and always and hand out down to your family the value, the earning potential, no different than farmland or any other type of thing in one's estate. How does it and why does it become something that anyone can have at some point?
It is confusing because it's called intellectual property, right? And you think property doesn't expire. But intellectual property is different because in the Constitution, Article 1, Section 1, Clause 8, it specifically says for limited times. And copyrights originally were just for 14 years. And then there's an extension to 28 years, and then 50, and then 70, and for corporations, 95 years.
Now,
in fact, this act...
Hold on a second. I'm sorry. Why is it that a person doesn't get the same love, care, and protection that a corporation does? Because corporations are people. I think I remember hearing that, John Rizvi.
Yeah. So, well, if you're a real person, you get the life of the author plus 70 years.
Okay. So
for a corporation, there's no life of the corporation, but they get 95 years from publication, and that's. A lot of people have referred to these extension acts as the Mickey Mouse Protection Act because Disney's lobbied quite a bit for extension of the copyright terms to protect their intellectual property.
So basically, the muscle and the power of the mouse is mighty compared to most of us. So previously, of all the other entities, all the other creations and the people, the minds behind them, and lawyers and suit and ties and great experience and patents like yourself, John Rizvi, with Sterling on the big one, talking to the patent professor, they had that might to be able to go to the courts and fight to stretch that out to nearly 100 years.
They have. And it's quite a bit. It's a lot more protection than was originally planned for copyrights. And now, once they're in the public domain, it's up for grabs. Anybody is able to do whatever they want with the characters, change them, put them into new films. The only thing that they have to be careful about is not to confuse consumers into branding, because Disney has kept their trademarks, which do not expire. So they can't sell goods or services and confuse consumers as to who the rightful owner is.
So you can't slap down on these old drawings as a still on a sweatshirt and sell that because it could be confusing to someone actually thinking it's a Disney property. But you could create another film or some other type of comic that could go in that circumstance. Is that right?
You could. You can't, if you create products, it's not saying you can't create a T-shirt and put the Steamboat Willie version of Mickey Mouse on there. But you have to make clear that you're not licensed by Disney or in any way affiliated with Disney, or else, even though you're not violating their copyright, you could be violating their trademark rights. Now, as far as the new movie, they didn't wait very long before announcing yesterday, on the day the copyrights expired, was an announcement of a Mickey Mouse remake, Mickey's Mousetrap, which is a horror version that's expected to be released sometime in March. but it's already completed. So clearly, a lot of people are keeping this date in mind. It's been known for some time that the rights are going to expire, and they're ready to pounce on the rights right away.
And that's pretty much what happened with Winnie the Pooh, or some incarnation of the early Winnie the Pooh as well, yeah?
It did. The Winnie and all his friends went feral and started killing and eating each other. So, we've just seen the first of a long line of characters that are starting to come into the public domain. We still have over the next several years, Bugs Bunny, Bambi, Peter Pan, Batman, Superman. All of these are going to be coming to the public domain. So we're going to have to wait and see if these dark versions of these characters, if those films do well, because if they do, then there's going to be a lot of commercial interest and of almost a new genre of expired copyright characters being remade into new versions of those characters in new films.
It's an interesting thing when you start utilizing other people's work, their creations, and on their backs, then you can earn by only creating something new using the same actual device, for want of a better way to describe it, which was the whole point of, I guess, an early on being able to protect it, was to keep anyone else from utilizing it. How did they come up with these numbers, 14, 28, 50, 70, 95 years? Just negotiation over time within the courts, people fighting it out?
Exactly. The Constitution doesn't really provide much guidance other than that it's for limited times, the protection for authors and inventors. So gotcha. Then it just comes to be argued as to what the limitations are. And certainly the duration of a copyright has expanded throughout the years. There was a lot of hope a few years ago that it would expand even further past 95 years and give Disney additional time to profit from the exclusive rights to Mickey, but that there was no further extension. So I think it's a safe bet that 95 years is the most we're ever going to see for the duration of a copyright.
Talking to the patent professor, as he's known. He's a patent attorney, John Rizvi, with Sterling on the big one, Mickey and Minnie, early incarnations now in the public domain, now horror film, soon to be, if it's not already out there streaming someplace perhaps for quick changing of money and so forth. Over the years, I'm curious, is it like the pharmaceutical business? I have a friend who works for a fairly large pharmaceutical company, and their licensing or patents and ownership of medications is limited, different years in this circumstance. And from what he explained to me is that when they had gotten to an end of one particular like antibiotic, what they were able to do is sort of, as he described it, and this is way beyond my pay grade and understanding, they reversed the helix of it and altered something molecular structure-wise as they put it together, which then allowed them to then sort of recertify it and extend their ownership of that product. Is that the same when it comes to other creations as well, where you can make a slight interpretation change to that, or am I missing something?
So there's different doctrines. You have in patents, if you create a new improvement and it's seen to be a non-obvious improvement, you can get a separate patent on that non-obvious improvement and extend your intellectual property rights to that patent in that way. As far as copyrights, you certainly can have a derivative work, which is an improvement on the original, and Disney's done that with Mickey Mouse as well. So the version that's in the public domain is the black and white version of Steamboat Willie, but there is a version of Mickey Mouse where he has red shorts and white gloves, and that's an improvement. So Disney was able to expand their monopoly by copyrighting that improved version, but not for long, because even that improved version is expiring on January 1st, 2036. So we have about a dozen or more years before that version and basically all versions of Mickey Mouse are going to be part of the public domain.
You say all of them, so you can't just incrementally start making alterations to the way he dresses or somehow a change in any character's face or design that then extends it and sort of lays it out there. Once that it all expires, it's just out there, and then you hope they've created something else to keep those monies flowing in, I guess. Is that correct?
Exactly. They do need to keep, and that's part of the purpose for the rights to be limited, so that to keep pressure on to continuously improve and have derivative works and improvements and non-obvious changes to intellectual property.
How does it work with music? Because when I think about it, I think maybe design and architecture or design and mechanical processes or systems. I mean, there's a lot of layers to licensing and ownership and how it may improve construction circumstances or manufacturing of some type of transportation, a vehicle or a train, whatever it is. There are some differences in the way these all come together, correct?
There are, and music's is such a specialized area. They bring in experts to try to determine if another song is a copy or an improvement, if it's an infringement, and unfortunately we see a lot of those cases get played out in court, and that's a whole different area of legal specialization within intellectual property.
A lot of layers, and the idea of derivatives. I mean, you could argue that. The first song, after the first song that we are aware of or composing, a property, everything subsequently is derivative. So, I mean, it gets weird and dicey as far as ownership, I guess, and some bigger brains than my own, I guess, have fought this out over the years. It's very interesting over time, and you think about, children and grandchildren that are, somebody created something and they want to be able to give them something that is able to take care of them in their lives the same way it would be if you started building houses or cars or something else that's actually tangible that you can see, feel, and touch. That gets deep real fast. How much of this type of litigation goes on that we don't hear about where people are fighting over these things?
So a lot of it you never hear about because it gets settled out of court. Certainly, especially when it's the alleged infringer is a large corporation. They are worried about the impact on their shareholders, their stock price, their image in the marketplace. So a lot of times the cases are settled without anyone having heard of them.
And if I work for someone else or someone works for me and may have a contract, they create something like the classic story of like the carbon paper guy or the Post-it note person who came up with this idea. They were working for whatever company it is. And you think, well, that's billions of dollars over generations, technically, or however long it is. And they may have gotten like a new pen or a watch or a $50 bonus if they were lucky, right? That's just the nature of business and the cost of working for someone else under their shingle. Is that how that plays out?
That is. And in fact, a lot of companies now are requiring employees to sign employment agreements where anything they invent during the course of their employment automatically belongs to the employer.
Mm. And that can get pretty nasty, right? Or if I guess you could argue that you created something. But what happens if somebody creates something and they quit and then they have to wait a window of time? And then if the company decides that they could find out that maybe you actually did it while working for them, they might want to sniff out some of that cash and ownership to get you later? I'm not plotting or planning, John Rizvi. I'm just thinking of every contingency because, I mean, there's so many ways that this can be diced up and looked at. I mean, it's a lot of facets to this.
And you'll see when the cases get litigated, it gets messy. During discovery, they look at computer records, they pull phone records. So if you're inventing at work and you're using your employer's cell phone that was issued to you, and you're using their laptop, their laboratory, their equipment, then that provides them with a great avenue to try to claim that they should have rights to that intellectual property because it was developed during working hours on company premises. They're certainly using company resources. And that's if they don't have it in your employment agreement that the rights belong to them. But that's becoming very rare now that companies won't have an employment agreement that covers intellectual property.
And we've talked about this before, and I appreciate you being so generous with your time talking to John Rizvi, by the way, about it started with Mickey and Minnie and the original, I guess, incarnations of them, which are now out in the public domain. We'll be seeing some creepy horror movies and porn and who knows what else with that sooner than later, talking with a patent professor about it. There are just so many layers to it. It's interesting. What have I not asked, and what's like the most unusual thing that you've come across doing what you do in relation to this before we let you bounce? Because the mind wonders. I mean, I could spend hours just sort of sitting around and pondering this.
Yeah, well, I mean, you get, it's funny because, when I was in law school, this is almost 30 years ago, I had professors that would say the exam questions come from real life because the stuff that happens in real life is stranger than anything he could possibly write up. The things we see in intellectual property, the theft that takes place, it's just so important to get your rights protected. File the applications as soon as possible. Be careful not to reveal your idea to anyone, because we've seen in our field, litigation between spouses, husbands versus wives, on who came up with the idea, parents versus kids. Intellectual property, it's just critical to get your filing in and make sure it's protected, because otherwise it becomes extremely difficult and time-consuming in litigation to try to iron out who owns what.
It's like divorce and custody issues, but it gets deeper and nastier because you get corporations involved, and sometimes people are incorporated too, which is a whole other thing. John Rizvi, I appreciate your time. How can people find out more about what you do as the patent professor?
Yeah, so our website's thepatentprofessor.com, and that's our handle pretty much everywhere across social media. Instagram, Facebook, Twitter. Just type in The Patent Professor and you'll find us.
Thank you for making time. It is thought-provoking, quite interesting, and as so many people globally have grown up with the mouse or some incarnation of him, it's going to be interesting whether it's Winnie the Pooh, this, and over time, even more of it starts getting twisted and morphed in the ways that maybe you don't want your kids to see, or certainly never anticipated. I hear Walt spinning in his grave right now. Take care of yourself, John Rizvi. Have a fantastic New Year. We'll catch up with you again sooner than later, my friend.
Take care. Always a pleasure.
Thank you, sir.